All right, everyone, we're back. This is Eli from Mile High Pokemon. Today we're going to be talking about the rest of the anti-SLAPP motion that Rattle filed in order to throw out the suit that Sean Bassik filed against him. As a reminder, as always, the content in this video is not legal advice. If you need counsel, find your own lawyer. And also, the opinions here do not represent that of my employer. So let's get started. So if you remember where we picked off last time is Michael Baristo. I don't know if he ever says his last name like that. I presume not. But Rattle essentially filed this motion in order to get the case thrown out on the basis that he was exercising his First Amendment right, and this lawsuit itself was used to deter his ability to, speak freely. So once again, as a reminder, this is Bassik's brief and sort of opposing throwing out the motion. He begins again by saying that Rattle allegedly kept only looking for evidence to confirm his beliefs rather than reviewing all the information he had in front of him. And then they restate the 4 statements that were allegedly fraudulent, which you remember is that Bassik committed fraud by selling non-factory cut Pokemon cards, that Bassik committed fraud via 2 rigged fake Charizard giveaways, that Bassik worked with Evan Mathis to sell Doctor Collecting cards, and that Bassik had a special agreement with CGC to pay for services after the fact rather than ahead of time like everyone else. So what they have to do here is do 2 things. First off, they have to sort of argue that the lawsuit is not made out of malice and is rather made out of good faith, or that it's not essentially being used to aggressively in order to shut down Rattle's speech. The other thing that they need to do is essentially show that Rattle's First Amendment claim is not valid. That's what they're trying to argue. So before that, though, they're talking about the stage that we are in the lawsuit. They argue the motion is untimely and an improper attempt at early summary judgment. Now, usually the way lawsuits work is that the party file a lawsuit, and then the other party denies or accepts every claim that they make. So essentially, Bassik would say Rattle did X, Y, and Z. Then Rattle submits a response that says, no, I didn't do X nor Y, but maybe Z, or whatever. And then usually what happens is that that right then or before, the defendant will file a motion to dismiss. And the way that works is you essentially read the complaint, what the plaintiff says, and you ask the question, if we accept everything here is true, was the law still broken or the claim still real? But usually, because courts prefer not to throw out stuff that right away, right after the first motions, they'll deny that, and then they'll go to discovery. And the way the discovery works is, both parties exchange information, you have deposition, and then after reviewing all the evidence, usually the defendant will try to throw out the case a second time. And this time the standard's a little different. You look at all the evidence, and you say, okay, we're going to look at Rattle's evidence and Bassik's evidence. If there's ever a direct contradiction, then the plaintiff wins because there's a preference to keep lawsuits going. But if reviewing all the evidence, there's not much there, then the lawsuit gets tossed. The way that anti-SLAPP provisions work is that it takes that second type, the summary judgment, and it bumps it up. And so you can actually try to get a lawsuit thrown out based off the evidence before you've done discovery, so before both parties have seen each other. So Bassik's lawyer here is arguing that this is inappropriate. We should have discovery first, look at his evidence and mine, and then and only then can we entertain a motion like this, which is not how it works, because anti-SLAPP motions exist in order to prevent parties from getting sued wrongly. And if you're getting sued wrongly, going through discovery is a large hassle. It can cost a lot of money, you pay lawyers and all this stuff. And so we recognize that even making someone go through discovery, even if they're going to win, is sort of a punishment for speaking. It's still going to deter people from speaking because it's a huge pain in the ass. Yet here Bassik is essentially saying that this is too early to throw the case out. Even if you disagree with us now, give us a chance to look at the evidence, let us look at Rattle's emails and Discord server, and then if there's nothing there, then you can dismiss later. Also, they use this great word blunderbuss, which is apparently a fat pistol that was used like 200 years ago, which has a scattered shot when you shoot it. I did not know what a blunderbuss was, but now you know, now I know. All right, and so once again, in order for Rattle to win, he has to show that he was exercising a constitutional right, which is the First Amendment, and number two, that Bassik sued with the motivation to deter, retaliate against, or prevent the exercise of the First Amendment right, which is sort of what I covered as the first two bases. So first, they're going to argue that Rattle was not protected by the First Amendment. How are they going to do that? Well, first, they're going to say libel is not protected speech. The statements he made were libel, so they're not protected by the First Amendment regardless. Now, of course, if you remember, Rattle's original motion argued that everything was protected because it was all either true, so it wasn't libel, or it was, exaggeration, or it was opinion, but essentially it was all protected speech. So they disagree. They say that the word fraud has a meaning, and that anyone hearing the word fraud interprets it, any reasonable viewer would interpret it as breaking the law. And so when you're calling someone a fraud in a video, that heavily implies that they are breaking the law. So that is a statement of fact, and he argues that's not true. And of course, at this stage, Bassik sort of gets some of the benefit of the doubt. So that is part of it. They're arguing that under Rattle's interpretation, there's a free pass for defamation on the internet because essentially everything on the internet is hyperbole. So like anytime there's like a scandal or videos made, like it's all hyperbole, and so it would make it very, very difficult adopting that argument to ever sue anyone. That's their argument, that it would erode libel law entirely. And then finally, they argue that Rattle's statements would not have been interpreted as an opinion because he has portrayed himself as the authoritative voice on Pokemon. In his motion, for example, he argued that Time Magazine and other essential sources have cited to his work, that he's been proven right many times. And so Bassik is arguing that anyone who watches Rattle's video, reasonable person who knows his background, is going to interpret what he says as truth, not his opinion. And so that's why he has to be more careful. That's the argument. And then they're also making this other argument that even if Rattle didn't say anything explicitly, sorry, whenever I see Baristo, I know it's Rattle, but like in my head, I need to take a second for that to click. But anyway, they're arguing that sometimes when you speak, you have implications. Like you don't say stuff explicitly, but you suggest that there's other evidence there. So when you call someone a fraud and say, oh, they've been ripping people off, and look at the result, look how much money they're making, sometimes there are implications. If you say, I've seen all this evidence, that like there's something, evidence that exists that doesn't actually exist. So they're arguing that essentially Rattle, through his speech, has implied that Bassik has done many things, that there's not evidence to support, and that it doesn't matter if he didn't say a lie explicitly. Even the implication that he did something that was a lie is enough to sue. This is what they're arguing. On that basis, that it's not protected, and that his statements were factual as opposed to opinion. Then he talks about each of the specific allegedly defamatory statements one by one. So he says it's defamation to call him a fraud by selling non-factory cut collector cards. I don't know why they say collector cards, but whatever. And essentially they're saying there's no evidence to support the fact that he knew about it, or that in the cases where he did sell cards that it wasn't disclosed. Because if you remember in his earlier amended complaint, he said, well, the cards I sold had cut corners, or I told on my website, said on my website how it was made, and so anyone would know essentially what had happened to these cards and where they were cut. And they, for example, produce a graded card where it gives the sheet position, so anyone would have known that it was cut. That's what they're arguing. And then they introduce affidavit from Rusty, who essentially said that cutting sheets outside of the factory is not fraudulent behavior. Now, of course, Rattle isn't saying that it is. Rattle is saying that cutting them outside the factory, not disclosing that is where you would have deceptive behavior. But essentially they're trying to use Rusty, who also submitted an affidavit for Rattle, trying to use it against him, being like, even look at his own guy who supports him, saying that this isn't fraud. And they're really trying to put this on the authenticators. They're like, okay, CGC, and they also mentioned PSA here, they're the ones grading these cards. If they think something's legit, like these are the two top grading companies in the world, if they say something's legit, why does Rattle's opinion about what's legit and what's not override the opinion of these grading companies? And so labeling something as a fraud when the grading company said it was real, especially when they have such a big stake, when they have the guarantees and stuff like that, is ignoring evidence that doesn't support, the argument. That's what they're arguing. Essentially, that Rattle was being reckless by not considering the fact that these authenticators had authenticated it. Then they talk about the whatnot wheel spin, which we talked about before in the last video as well, which is the idea that Rattle had spoken to several people. Several of them were associated with the giveaway itself. They all said that it happened, and they're trying to argue that any of Rattle's other sources were randos on the internet, and their credibility is shot. And that keeps going about the Omega mystery boxes. A lot of this is retreads from the amended complaint, as we discussed. For example, the stuff about the selling cut cards for Evan Mathis. He argues he was just a consigner, and that he actually didn't know what Evan Mathis had done. And then the special deal. Now, this is the weirdest one, the one about the special deal, because to me, even if Rattle was reckless or lied about Bassik having a special deal with CGC, I just don't understand how that's a defamatory statement. Because who cares if you get special pricing or a special deal with someone else? That's not deceptive. That's not fraud. That's not libel has to be a false statement of fact that, causes harm to your reputation or causes some sort of damage. What damage is there when you have a lie that isn't actually damaging? What if I also said Sean Bassik had $50 in his bank account and he actually had 100,000, right? Yeah, I mean, it's a lie, but it's not really damaging. And so that's why this last, the fourth out of the four statements here, I don't even see as libelous for that reason either. And then he comes back to this actual malice standard. If you remember, if Sean Bassik is considered a public figure, limited purpose public figure, then he has to show that Rattle acted with actual malice, which means that he knew what he was saying was false or had reckless disregard for the truth. Okay, if he's not a public figure, if he's a rando, then you only have to show that Rattle was negligent. So Rattle essentially wants him to be a public figure. Sean wants to say, I'm not a public figure, I'm just some rando guy, and so I should have as much protection as every other rando. I shouldn't get less protection because I'm not a celebrity, is essentially what he tries to argue, right? And so he, once again, as we've talked about in the past, tries to downplay his status in the hobby and downplay the Pokemon hobby as a whole. For example, and also the nature of the controversy. So here's the big point. In order to be a limited purpose public figure, there has to be a controversy that exists, and you insert yourself into the controversy. For example, let's say there's a controversy over, in this example, it was about a nonprofit. So let's say the nonprofit stole people's money, right? If you're someone who works for the nonprofit just as a rando, then you're not a public figure, probably. But if you end up making a statement about the situation, or if you, are a marketing person and you are interviewed about it, then that is inserted yourself into the public controversy and you become a public figure and you get less protection because you've essentially chosen to hop into this huge public discussion that's going on. Sean Bassik is trying to say that he never had controversy before Rattle arrived. He says, at no point has a public controversy existed about Bassik or BBC. The only controversy is Burstow's strange targeting of Bassik. Rattle's not alleged, much less show any issue involving Bassik being debated publicly or with foreseeable and substantial ramifications for non-participants. So he's saying that, before Rattle started making his videos, Sean Bassik was just some rando, and the only reason a controversy exists in the first place is because Rattle made videos about him, that he created the controversy rather than there being a controversy to begin with and Sean hopping into it. And they try to essentially say that, once again, that Sean is sort of a rando, and that if he is held up here to the higher standard of being a public figure, then anyone engaged in commerce, anyone who buys and sells Pokemon cards, is going to become a public figure. That's his argument. That if I such a guy who's barely in the hobby at all, if I can be subjected to this, then anyone who sells Pokemon cards is not going to be able to sue when they're defamed. Second of all, he once again minimizes, as I mentioned, the Pokemon hobby. And right here, the sentence says, the narrow market of Pokemon collectibles is hardly an issue garnering public attention. That's, of course, ridiculous. And in Rattle's response to this filing, You will see why that is, but primarily it's because Pokemon is the largest media, property in the world. And if that's not something of a public concern, what is? Like, when can you ever speak on a company if the literally number one in the entertainment sphere, that's not considered a public concern? So then he says, even if actual malice applies, even if it's the higher standard, he argues that Rattle meets the standard, that Rattle acted with actual malice, that he knew things were false or disregarded truth. So he gives 3 examples. First, when it comes to the trimming and selling Mathis's altered cards, Baristo, or they argue that Rattle had no evidence of the trimming, and that essentially it was all conspiracy theories, and there was no hard evidence that Bassik knew about the alterations. And they're arguing that because there was literally no evidence, he's just like making associations, that shows actual malice, that he was reckless in his and disregarded the truth. The second example he gives is about the wheel spin winner, how he contacted him, and the wheel spin winner said that he had received the card and didn't remember where it went. And essentially says that Rattle disregarded all the people who were actually in on the wheel spin, who had been there, and instead defers to this rando on Instagram, Ashland Fox. And we talked about this in the amended complaint. And they're saying that Rattle had disregarded whether the allegation was true or false because he prioritized this rando person on the internet over all the people who had participated in the wheel spin. And finally, he talks about the Magic the Gathering cards, the artist proofs, and says that there was actual malice because the website, Bassik's website, disclosed how these prints were made, and that by calling him his behavior deceptive or fraudulent, that Rattle had disregarded the fact that Bassik had allegedly been transparent about how these cards got created. So sorry I've been repeating myself a bit. If anything's not making sense, please leave a question. I'd be happy to clarify. But once again, I'm just sort of going in the order of the documents, and so maybe I wouldn't have, organized it this exact way, but that's the way this is organized, and I'm just walking you through the filings. And then he talks about actual malice in terms of ill will. So, all the name calling, all the hostile behavior, the fact that Bassik, or Rattle, wasn't willing to take email statements from Bassik and was only willing to do sort of a one-on-one call or conversation. That's the allegation. All of this shows that Rattle was out to get Sean Bassik. That's what he's arguing here, and that that all lends itself to be evidence of actual malice. And then they just touch a little bit about the other claims, saying that anti-SLAPP provision should only apply to libel claims and not to any of the other stuff, which is not how that works, because I think it's all the First Amendment related activities. All right, so we finished up with the response, and now we're going to go on to Rattle's reply to this response. The legal language is a little complicated, but you have a filing, you have a response, and then you have a reply. So whenever you make a motion, in this case to get the case thrown out, after the party responds, you have one more attempt to make your argument, and that's where we're going next. Okay, and here we are on Rattle's reply. So once again, Rattle's arguing to get the case thrown out. My cat's on me right now. He came on during the break, so if you see him walking around, that's why. But he's cute, so it'll be worth it. So I'm going to actually read out loud some of this because I think that Rattle's lawyers do a good job putting the stakes at the forefront. So it says, plaintiff Sean Bassik said he would bankrupt defendant Rattle, a Canadian Pokemon trading card reporter and YouTuber, if Baristo published a recording of Bassik that Bassik thought he made. Baristo did not make any such recording, but he did say in a few YouTube videos that he had looked into Bassik and found some of his conduct shady and suspicious. Baristo told his viewers how he came to that conclusion, by interviewing people with knowledge, by conversing with multiple independent sources, and by drawing from his deep knowledge of the collectibles market, extensively detailed his sources, and implored viewers to conduct their own research. He warned viewers he did not have any inside knowledge, but he believed from publicly available information that Bassik's activities marketing his products as uniquely fair in an industry rife with fraud and associating with known scammers were worthy of further investigation. Bassik sued him for silence and vengeance. So they start off by saying, look, Rattle never claimed to know something that was non-public in this case. What Rattle did is he looked at all the publicly available information, what he had heard, and based off that information been like, I'm concerned about this. Like, I don't know if I would trust him. Keeps going. Bassik complains Baristo reached the wrong conclusions instead of accepting the version of events Bassik's witnesses pushed. Baristo did not ignore these witnesses. He spoke to them and found their story suspicious, reviewed multiple independent sources, and published his own views. He neither hid his sources nor implied unexpressed facts. To the contrary, he shared everything he knew and implored his viewers to decide for themselves. Even if Baristo ultimately got some of the details wrong, that does not make him liable for defamation. So, again, here what they're saying is, Bassik's lying about disregarding sources. Actually, Rattle featured the sources that disagreed with him in his videos. His viewers saw that not everyone agreed with his interpretation of events and that there were facts contradicting his narrative, but he presented them honestly to the viewers and he was transparent about it. So that's the intro. Then they move into the public figure stuff. So remember, it's much easier to get the case dismissed if Sean Bassik is considered a public figure in the Pokemon market. So we'll begin there. Oh, I don't see where that part went. It's right here. Okay, so I'll go back to part 2 in a second. So let's start here. Essentially, whereas Bassik argued that Pokemon is a small media thing, and Bassik was not controversial ever before the video started getting made about him, Rattle's saying that the portrayal is totally wrong. Fraud in the Pokemon market is a widely covered public issue, despite Bassik's contrary claims. So they argue the public issue isn't about Bassik. It's not about him at all. The public controversy is the fact that Pokemon is the largest media product of all time. Pokemon cards are the #1 trading card game, and there's a ton of fraud that happens here. So the controversy is that, we don't know who to trust. There's a lot of scams happening. And so if you are someone who starts selling cards in a big way and trying to make your name in this, then you are essentially putting yourself into a market where there's high scrutiny because there are so many scams. He should have expected that getting involved in an industry like this one would lead to essentially having more eyes on him and more conversations about him. He's not just some rando seller. Of course, some of this comes from the very fact that Bassik portrays himself as an expert in the industry. As the sentence says, but Bassik did not just dip his toes into the Pokemon market and keep a low profile. He bought and sold millions of Pokemon cards, including some of the most significant finds in Pokemon card history. So even if rando Pokemon sellers aren't limited purpose public figures, Bassik is, because Bassik marketed his products highly. He claimed that he was setting a high bar with his mystery boxes, claimed that they were fair, and he associated with celebrities and sold huge and important and valuable cards. So he's not some rando seller. He is one of the sort of most visible sellers. And that's why he cannot pretend that he is obscure. They're saying that he's well known, and he should have known when entering this market that he would be seen that way. All right, let's also move up to right here. They once again reaffirm that this lawsuit is essentially they're out to get Rattle. That is what Rattle's arguing, that essentially he wanted to bankrupt, even if we accept Bassik's version of events, that he wanted to sue Rattle not because of his videos, but because he was filmed allegedly without permission. That is so spiteful in itself. Can you imagine someone records you in B-roll without permission and you decide to bankrupt that person? That example right there shows they're arguing that the lawsuit was filed out of malice, out of hate, not out of good faith. Where else? So the next thing they say is about context. How Bassik's lawsuit is completely taking stuff out of context. That Rattle's videos are an hour long, and Bassik is taking out individual sentences or even just words out of these large videos. And they're arguing that libel claims are decided on the context. And there are even cases depending on the audience, even a technically false statement may nonetheless be considered substantially true. The reason that may exist is you could imagine someone giving a joke or exaggerating or being sarcastic, right? The statement itself is false, but if you listen to the tone of their voice, if you hear it in context of everything else they said, you would know that this isn't actually trying to purport to be true. And so what we really have to do is look at an average viewer watching this hour-long video. Would they come out, thinking that Rattle had lied based off what we know? Or disregarded, disregarded whether it's a truth or a lie, the standard for actual malice. So that's what they're arguing, is that everything's taken out of context, and the right way to go about this is look at what he's saying within his hour-long videos. Then we're looking at the actual malice standard itself. So in order to show actual malice, the standard is high. You can't just show that someone was being malicious. So actual malice doesn't actually mean malice, like the way that we think about it as used in English in our day-to-day conversations. It means something very specific. It means you have to show that someone knew what they were saying was false, or that they entertained serious doubts as to its truth, or recklessly disregarded whether it was truth, right? That's the standard. And he's arguing that even if, Rattle used a bunch of potty language, even if he was being really aggressive, even if he was really ragging on Bassik, none of that meets the definition of actual malice according to what the technical legal meaning is. For example, there's no evidence he introduces that Rattle knew what he said was a lie. Now, of course, Bassik is going to argue, or what is implicit in his argument is that, well, let's get to discovery. Let's look at Rattle's private messages. Let's look at Rattle's Discord, and then maybe there will be a message where he knows he's lying. That's what he especially wants to go on a fishing expedition to try to see if there's any statements that make Rattle look bad. But that's why they're trying to get to the discovery step and what they're trying to show. They also argue, Rattle does, that the disclaimer he provides is not just some defamation shield, but actually, if you read the disclaimer, it tells viewers how they should interpret the information presented to him. That Rattle is doing his research to the best of the abilities, he's trying to present both sides, that he's giving his opinions and conclusions based off the available information, and that if you read the disclaimer, you should have a better understanding of how to interpret the context of Rattle's video. And then they talk about how high the actual malice standard is. That it has nothing to do with professional journalistic standards. And there's a lot of case law on this that says it is well established that failure to investigate, sloppy investigation, poor reporting practices, and others like that are not actual malice. That means even if a reporter does his job very poorly, or her job, and they screw up and they're negligent, that's not actual malice. You don't have to be a good reporter to have First Amendment rights. You can be a sloppy one, or even break rules, and you'll have protection under this standard. So there's a lot of favorable language from previous cases that say, for example, the idea that even an extreme departure from professional standards could constitute actual malice has been emphatically rejected in favor of a strict standard. Thus, whether the publisher's conduct in determining a source's credibility was a highly unreasonable departure is not part of the analysis. Even the complete failure to investigate when a prudent person would have done so is not sufficient. So there's actually a few cases that are cited here which are favorable in terms of their factual circumstances. So, for example, in this case, Connigan, a newspaper published a story about an attempted bribe. They only had the quote of a single witness. They did not do any other research. They did not include quotes from anyone else. They literally just said, here's what one person said, and then printed it in the newspaper. And the court said that that is insufficient to support a finding of actual malice, because there was no evidence that they had information suggesting that the information was false, even though he should have investigated more thoroughly, just on as a practical matter or as a moral matter. There's another case here, Hawks v. Siri, where the defendant, with no evidence at all, accused a doctor's wife of being a prostitute and a cocaine user. Despite no evidence supporting that claim, the First Amendment still protected the statements, because a reasonable person would understand that this was hyperbole and not a legitimate statement. So it's not the defendant's job to show that they had exercised diligence, but it's the plaintiff's job. It is Bassik's job to show that the actual malice existed. Thus, the First Amendment protects reporters and YouTubers equally, because all of them have this high level of free speech protection. That's the argument being made. And then they go into the three examples that Bassik gave where allegedly Rattle acted with actual malice. So first, they talk about these sales of altered cards from Mathis. And essentially, if you remember, Bassik has argued that Rattle had no evidence saying that Bassik knew that the cards were altered. But that's not enough for actual malice, because he being Rattle, gave the conflicting perspective. He reported on it. He reported on Bassik's denial of the trimming and knowing about the trimming. So he gave both perspectives, is what they're arguing here, and that he didn't ignore information that said otherwise. And actually, the same thing is argued here with the second and third example. So in the second example, they argued that the Rattle should have deferred to all the people who participated in the giveaway rather than deferring to this random Instagram user. And Rattle's arguing that he was fair in his reporting because he gave the contradicting perspective. He told his viewers about Ashmo's claims. He told the viewers about the denial on Sean Bassik. And so he gave both perspectives. And finally, the same thing with the magic cards. He covered the website where it disclosed how they were made. And not just that, but Rattle was concerned that because the cards were not actually sold on the same website where it was disclosed, that Sean would try to sell these magic cards on eBay or another platform and would not disclose on those other platforms how these cards were made. That essentially the only way to find out what happened to him would be to go to an outside website, and that Sean was not being upfront with his sales practices. And so that's why he argues, Rattle argues that in each case he was very careful and he gave all sides, all perspectives. And then we talk about good faith interpretations, which is the inferences that Rattle made. So he had facts in front of him. Yeah, he may have made assumptions, or he may have linked A plus B equals C. But all of that was good faith. He didn't make stuff up explicitly. And all of his assumptions or his allegations were within the realm of possibility or reasonable, given the facts he had in front of him. Finally, they once again restate that Rattle had a ton of opinions, and none of that is actionable. You can't sue for libel because of opinions, only statements of fact. And even words that seem factual are not really in the context that they were said. For example, fraud. Rattle did not mean fraud as in breaking the law. Fraud as in, like, hey, this guy is being shady, or engaging in deceptive practices. Same thing with rigged. Like, these are all words that have connotations of opinion. Rattle did not intend them to indicate legal issues, nor did a reasonable viewer would they interpret this to be a legal allegation. And finally, they say that the other claims should also be dismissed here because they're all related to Sean's want to get back and to bankrupt Rattle for his speech and for his practice of First Amendment rights. And so that even though the other claims like tortious interference are not exactly First Amendment related claims, they were raised because of Rattle's speech, and so that they should be included in the anti-SLAPP provision. And that's pretty much it of all the major arguments. And from here on out, we'll be awaiting the judge's decision, which has already been made. You can go look it up. But in the next video, I'll be discussing the judge's decision, the implications, how to interpret it, and we'll go from there. See you soon.